go down there, meet with Mr. Arjima, I assume, or Mr. DeFolt next week. All right. This is case number 24 CR 122, State of Ohio versus Tara Renee DeHaas. Present for the state is Assistant Prosecuting Attorney King. Present for the defendant's attorney Danielle Witt. And you are Tara Renee DeHaas?
Correct.
All right. This matter was set today for a plea on an entry granting intervention in lieu of conviction. The court on October 25th ordered that a pre-hearing report be conducted and the defendant be assessed. I know that she's in a treatment facility, so I know the assessment's been done, but we do not have a written report from the probation department, and the bailiffs have called, and they don't think one was done, and the officer that does most of these, Mr. Fulton, is on vacation. So
Tanya said they never received the order to do it.
they didn't receive the order to do it. It was ordered. Yeah. Why wouldn't they receive it? Okay. Well, okay. I'll have to have a talk about that. All right. So there was not one done. So we're going to have to continue this. And you need to go down to the probation department and tell them that you're there for your intervention in lieu of conviction. That you need to have an appointment for that. They can probably do that by Zoom or by phone.
Okay.
If they can't do it today. Mr. Arjima does some of these, but I don't know what his schedule is today. The other one, Mr. Fulton, is off. So they indicated that they did not receive the order. So apparently the clerk did not send it to them. We'll continue this until, let's see. Today is the 20th. Let's make it December the 11th in the morning. You available, Ms. Witt?
I'm scheduled in Adams starting at 9 o'clock.
All right.
I have a sentencing that's scheduled in here at 9. I was going to get with Marcia to ask if I can move that up to 8:30 though.
Okay, let's do December the 18th then, if you're available. That would be about 9 o'clock.
Can we do that any earlier? I'm supposed to be in Adams at 9:30 that day.
Yeah, we can do 8:30.
Okay.
I actually have arraignments at 8:30, but we could go ahead and do this first and then do the arraignments afterwards.
Thank you.
All right. So go down to probation, and I don't know that they'll be able to do the interview today. They'll probably have to schedule it. And again, you can give them your contact information, and we'll go from there.
Thank you, Your Honor.
All right. Thank you. All right, this is case number 24CR140, State of Ohio versus Joey R. Fender. Are you Joey R. Fender appearing there on the screen marked Zoom user?
Yes, sir.
All right, this is a pretrial being conducted by Zoom. As indicated, Ms. Fender is appearing on Zoom. Appearing on behalf of the defendant is her attorney, Jacob Wagner. Appearing on behalf of the state is Assistant Prosecutor King. The defendant is charged with six counts, 3 counts of aggravated trafficking, 3 counts of aggravated possession of methamphetamine. I believe this is the final pretrial, and I believe we have a trial date coming up in December.
19th, sir.
All right, December 19th. All right. Now, is discovery complete on both sides?
It is from the state, Your Honor.
Ours was filed this morning, sir.
All right. And you have no pretrial motions?
No, sir.
All right. And what's the status of any possible resolution of the case without trial?
If I may, Mr. King.
Go ahead.
Your Honor, state made the original offer was related to my client. Since that time, myself and the state's been back and forth on different offers. We've came to, I think, a final offer has been presented to my client. She just hasn't accepted or rejected it yet. We're well aware of the 2-week rule, sir. So we will have the answer to your assignment, Commissioner, about a plea date or jury trial date very shortly, Your Honor.
All right. Any other matters we need to discuss then?
No, sir.
All right. Ms. Fender, I see here that according to probation, you've not reported since October 17th. You're required to report. If you don't report by the end of the week, that would be Friday, the court's going to issue a warrant for your arrest. You're required to comply with the pre-trial conditions of the court. So you contact the probation department and make an appointment to be there no later than Friday, 4 p.m. And I see Officer Benson is monitoring this. And Officer Benson, if defendant is not reported by 4 p.m., let the court know. On Monday morning, there'll be a warrant issued for her arrest.
Yes, sir.
All right. You understand, Ms. Fender?
Yes.
All right. Thank you. All right. All right, State versus Alan R. Green, 24CR160. Are you Alan R.
Yes.
Green, appearing there on the screen, marked Alan Green?
Yes, sir.
All right, this is a pretrial hearing being conducted by Zoom. Mr. Green has been indicted for aggravated trafficking and aggravated possession of methamphetamine. His attorney appearing by Zoom is Jacob Wagner, appearing on behalf of the state, Assistant Prosecutor King. Let's see, I believe this may be the first pretrial. Yeah, this is the first pretrial. Final pretrial set for December 18 and trial date set for January 16. All right, I see the state has complied with discovery. You received that, Mr. Wagner?
I have, sir.
All right. Well, your discovery will be due by the final pretrial. Do you anticipate any pretrial motions?
Not initially, Your Honor.
All right. And has there been a written plea offer provided?
There has, sir.
Is your client aware of it?
No, Your Honor. He got off to rehab before I could catch him, but I'll get it to him.
All right. Are there any other matters need to be discussed at this time?
No, Your Honor.
No, sir.
All right. Stay in touch with your attorney, Mr. Green, and we'll be doing your next pretrial December 18th by Zoom. Thank you.
Okay, thank you.
All right. Are you out? Alexis Ruffing. Case number 24CR159, State of Ohio versus Alexis Marie Ruffing. Ms. Ruffing's appearing on the screen, marked HCPD. This is a pretrial being conducted by Zoom. Her attorney is Jacob Wagner, appearing from his office. Appearing on behalf of the state is Assistant Prosecutor King. The defendant is charged with 2 counts of aggravated trafficking, 2 counts of aggravated possession of methamphetamine. This is a first pretrial, final pretrial set December 18. Trial date is set January 25. I see that it looks like the state has provided discovery and a request, and you've received the state's discovery, Mr. Wagner?
Yes, in my computer file, Your Honor. Yes, sir.
All right, you'll be, your discovery is due by final pretrial. Do you anticipate any pretrial motions?
Not at this point, sir.
All right, has there been a written plea offer provided?
There has, but yes, I'm sorry, Adam. Yes, the state has, Your Honor.
And is your client aware of it, Mr. Wagner?
No, I was going to call her after this. Eric told me she was down probation, and I got a good phone number, sir.
All right. All right, any other matters to discuss then today?
No, Your Honor.
All right, your next pretrial is December 18. We'll be doing that by Zoom as well, Ms. Ruffing, so you'll be at the probation department. Thank you.
Sure. Thank you.
All right, what's up with the jail?
The jail should be logging in right now, Your Honor. We just got a hold of
If you could adjust that screen a little bit there, Deputy, it could just see the top of his face. You're okay now, we can hear, whoop. Yeah, you had the voice on. You're muted, there you go, you're all right now. If you could just adjust the screen a little bit downward so we can see him. He keeps hitting the mute button. Okay, there we go, we're good. Okay, Deputy, you'll need to unmute the screen there. Yeah, you're muted. There you go. Okay, you're good. Yeah, too many clicks. There we go. I can hear you now.
No, they did it again.
Okay, you're unmuted according to my screen. Can you hear me now? They must not be able to hear me.
Should on our end, you see the judge talking, we can't hear anything.
Okay, I can hear you all right. I'm not muted, am I? Nope.
Speaker's not working. Everybody says.
They just brought in.
All right, can you hear me now?
If the computer says the speaker's not working.
Oh, for God's sake. All right, case number 24 CR 149, State of Ohio versus Ronald Howland Jr. I need the Brigner file. Are you Ronald Howland Jr. appearing there from the jail?
Yes, sir, Your Honor.
All right, this is a Zoom video. Mr. Howland's appearing from the jail. His attorney is Jacob Wagner, appearing by Zoom, also appearing as Assistant Prosecutor King on behalf of the state. This is a first pretrial, final pretrial set for the 11th of December. We have a trial date of 12/19. Now, Mr. Wagner, I see we have discovery here, and your discovery, you did receive that?
I do. I have, sir.
All right. Your discovery will be due by final pretrial, and are you expecting any pretrial motions?
Not pertaining to the case. I was going to make an oral request here in a moment once the court's done, Your Honor.
All right. Did you receive a written plea offer?
I have, sir. I've not been out to see Mr. Howard yet.
All right. All right, and I'll note that the trial date was set only 8 days after the final because of the speedy trial issue. If there's going to be a resolution, we'd like to get it done as quickly as possible.
Yes,
Mr.
sir.
Wagner, you had an oral motion you said you'd like to make?
Yes, sir, Your Honor. I apologize. I briefly spoke to Mr. King about it, but I don't think fairly warned him I was going to bring this up today. Only, Your Honor, I've been informed that there is a bed available for Mr. Howard at the Recovery Council if the court would consider that. I have a letter here for the first time, but we missed the window on that bed. It's my understanding there is one available maybe this week if the court would consider if I file a proper motion to get him over to a rehab bed, Your Honor.
Take your hat off. All right. Mr. King?
Thank you, Your Honor. The state would be opposed to that request. This defendant does have a fairly lengthy criminal history and also has a prior felony conviction out of this court for failure to appear. So based upon that, the state is opposed to that request.
Well, I won't make any ruling on it this time, but if you'd like to file your motion with any information, then at the court will take it under advisement. I assume if he goes to treatment, we'd need to continue the case into January. You may want to speak to your client about that, about waiving time. I'm amenable to granting a continuance since, again, we set it fairly quickly because of the speedy trial, because he wasn't indicted until the 5th of November, and speedy trial was like, I don't know what date, 23rd or 4th or something like that of December. So I'll with reserve ruling on that until I see the oral motion, or I mean the written motion. Okay.
Yes, sir. I'll be out to see him this afternoon.
All right, thank you.
Thank you, Your Honor.
All right. Christopher Brigner? I thought it was Cassie Brigner. It's Christopher Brigner. All right, are you Christopher A. Brigner appearing there from the jail?
Yes, sir.
All right, this is case number 24CR158, State of Ohio versus Christopher A. Brigner. This is a pretrial being conducted by Zoom. Mr. Brigner is appearing from the jail. His attorney is Catherine Hatner, appearing by Zoom. Appearing also by Zoom is Assistant Prosecutor King. The defendant is charged with a co-defendant, Mr. Green, aggravated trafficking and aggravated possession of methamphetamine. This is the first pretrial, final pretrial set on December 11, and trial is set for January 16. Now I see that the state provided the bill of particulars and discovery, and you received those, Ms. Hatner?
I have, yes.
All right. All right, your discovery will be due by final pretrial. Do you anticipate any pretrial motions at this time?
Not at this time.
All right, well, if you do determine that any should be filed, they'll be due by the final pretrial as well. And have you received the written plea offer?
I have received a written plea offer. I have not yet been out to the jail to communicate that to my client.
All right. All right, are there any other matters need to be discussed then at this time?
No, Your Honor.
I'm aware.
All right, we'll have your next pretrial then, next month, Mr. Brigner, and your attorney will be talking with you before then. All right, I believe that completes the remote docket. All right, so have a seat over there, please. All right, the plaintiff is represented by Assistant Prosecuting Attorney King. Mr. Philip Webb is representative of the Health Department. And you're Albert A. Mast and Clara E. Mast?
Yes.
All right. All right, this is a hearing on a default judgment motion filed by the plaintiff. The plaintiff filed this complaint on June the 13th of 2024 against the defendants, alleging that the septic system located at 9581 State Route 138 is not operating properly, and that there is ponding of liquid or bleeding of liquid onto the surface, has distinct sewage odor, and other allegations in paragraph 3. Like the defendants were served with the complaint personally on July the 31st by Sergeant McKenzie. Answer date would have been 28 days after that, which would have been in August. On September 20, the plaintiff filed a motion for default judgment. Mr. and Mrs. Mast, what this means is that under the rule in the law, once you're served with paperwork, you have 28 days to respond in writing to the court serving a copy of the other party, the party that brings the action. So when you don't do that, that means you're in default, which means that they are entitled to judgment. The purpose of this hearing is to determine what the remedy should be, because you have not filed anything to contest the allegations. Now, Mr. King, has there been any discussions or anything with the defendant since the filing of this motion?
Your Honor, Mr. Webb, who's last name? Mr. Webb's been in contact with the defendants. There is still not a properly approved and operating sewage system on the property. Mr. Webb has explained to the defendants what they need to do in order to become compliant.
So there's been no effort made to comply? Is that your position?
They've made some effort.
I'm sorry?
Let's just explain. Can I explain the scenario to you, how we got involved? And
Well, we better do that by testimony. So go ahead and, if you would stand and raise your right hand, Mr. Webb, and be sworn. Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
yes.
All right. You can testify from there. Go ahead and inquire, Mr. King.
Could you please state your name for the record?
My name is Philip Webb.
Great.
I work for the Highland County Health Department. I do septic and trash nuisance complaints.
And are you familiar with the property located at 9581 State Route 138, Hillsborough, Highland County, Ohio?
Yes.
And do you know who owns that property?
Yes. And they're sitting in the court beside us.
And would that be Albert Mast and Clara Mast?
Yes.
And have you ever personally visited this property, Mr. Webb?
Yes, multiple times.
And can you explain what is the issues with this property?
Yeah. So the initial, I was driving by to do a water sample on a property next door, or a couple of houses down. And I saw a septic tank out of the ground. So at that point, because we regulate the sewage system, that's why we got involved. So seeing the septic tank actually out of the ground, sitting there, that's why I stopped by to see what was going on. At that time I met Albert. He was explaining to me when he was building his new house, when he was digging the foundation for the basement, he didn't want to destroy the septic tank, so he pulled it out of the ground. At that point, he also had a line that went through, so this was a gray water, a wash water line that goes to the adjacent property that runs to the ditch. So the septic system was compromised by him trenching a line through there. So the original mobile home with the septic was approved, but because when he built this house, he altered it. He had to acquire a permit through our office. He did not do that at this time. So we sent out an NOV. I think the solid waste was taken care of, so there is no trash or solid waste on the property at this time. But the septic system, he reinstalled the tank, and his black water goes to this tank. The Board of Health, I think at the last board meeting or two board meetings before, disapproved him to do a holding tank.
Did approve?
Disapproved.
Disapproved, okay.
So he cannot have a holding tank. So that's what he's doing right now. He asked permission. They denied him permission to do the holding tank. Typically, they'll approve it if there's a septic system able to be put in thereafter, if it's weather conditions. We've been out on the property. Chris Shope has been out on the property from the Highland County Health Department. And the only septic option that we have, based upon this new house with a new number of bedrooms, is an electric discharging aeration system. We also asked if he could get an easement from the neighbor to put a septic in. And I don't think that has been acquired at this time.
Would that easement be for the lines, the lease lines?
Yeah.
Okay.
Septic system will go on the neighbor's property.
You'll be able to talk to him. Anything else?
And then the well. So the well has never been approved. It is in a pit. It does not meet our code requirements. So it is so they have tied it into their house. That is under our jurisdiction too, and is not for human consumption. So their well is in a pit, doesn't meet the code requirement, has never been approved. And that is another issue that could affect the aquifer, which could affect the neighboring properties. Groundwater contaminating the aquifer.
All right, now, Mr. King, I don't see anything in the complaint about the water, about the well being a violation. I understand its relevance to the approval of septic, but if I'm only reading here in paragraph 3 that it's alleged that it's a sewage treatment system's not operating properly. So unless I'm missing something there, I don't think I can make any ruling on the well itself in terms of it being a separate violation, but only to the extent it relates to the approval of the septic. You agree?
I understand.
And that's the way the pleas are?
Yes.
Okay, all right. All right, now, anything further? Questions?
No, Your Honor.
All right, now, Mr. and Mrs. Mast, you'll have an opportunity to speak on your own behalf, to testify on your own behalf if you wish to in a moment. But right at this point, since you don't have an attorney, what normally would happen is if you had an attorney, is your attorney would ask Mr. Webb questions. It's called cross-examination, to try to bring out information and evidence that might help your side of the case. So if you have any questions you'd like to ask him, you may do so, not testify. You'll be able to testify here in a moment when they're done with their case. So if you have any questions you'd like to ask Mr. Webb, either one of you.
Yeah, as far as on like the one issue, which didn't bring my papers with me, the one issue that was saying gray water on top of the water, on the top of the surface or whatever it was saying, that's not true.
Well, that's not a question.
Yeah.
You're testifying, and I'll let you testify here in a moment.
Yeah.
Right now, you just need to ask, you have the opportunity to ask questions.
Right, yeah.
So if you have any questions, go ahead and ask him. If you don't, then you and Mrs. Mast, if she wishes, will be able to offer testimony on your own behalf.
Right, yeah. It's not that I really have any questions.
Okay, all right.
To ask.
Anything further?
No, Your Honor.
All right. Now, the plaintiff rests. Now, either or both of you may testify on your own behalf. Do you wish to testify and offer testimony on your own behalf?
You mean to say what it is, or?
Yes.
Yeah.
All right. You'll have to do that under oath or affirmation. You do not take an oath, I assume, so you would affirm under penalty of perjury. So if you want to testify, if you would stand and raise your right hand. And do you affirm that you will testify truthfully and answer all questions truthfully as you shall answer under the pains of penalties of perjury?
Yes.
All right, you may be seated. And just go ahead and, now this is your opportunity to testify. You can't argue, but you can testify. So tell me what the facts are that you think are different from his, or how he's wrong, or other facts that you think have some bearing upon the case.
Yeah. Like I was saying on the one thing he had written on, which is also my paper at home, that was written down for gray water on top of surface. The picture that I had at home that they'd taken, that's not true. There was no gray water at any point in time on top of the surface. And we moved in here from New York, and when we done our house, from what people that I had asked, I didn't realize that I had to get all these permits and everything for septic system and everything. So I took the septic out and just set it there. And once I was able to do it, I was going to get everything done right. So for right now, I just put the septic system in the ground until I'm able to spend the money and put the right system in. I'm working with my neighbor to let us go on his property with our septic system, but right now he doesn't want us to, and he doesn't want to sell it. Which Philip has said we didn't do that, but we did. We don't have phones like smartphones like you do, so we can't record anything. But we've done that, and he won't let us do it. And then the other thing he was saying about gray water, that goes in the septic. It's a regular septic tank. It's not, which we're using as a holding tank, and we get it pumped out every time it's filled from Apex Septic Service. And he's a certified septic system guy. And he pumps it out every time it's time to pump it out. So there's no leakage, no soil damage or whatever, contaminated, nothing. It's all in that tank and it gets pumped out, it's clean, and there's nothing wrong. And we had Chris out, the state put flags out for the only place that we have that we can go. And I have the guy coming to, which I called him to come do the soil investigation, and he can't come out until January, what was the date now, January 14th? I wrote it down at home, January the 14th, if I remember right, that he can come out the earliest.
And who is this that you're going to have
It's
come out?
Steve Hamilton.
And he is a contractor?
He's
or?
a STS soil investigator.
Oh, okay, all right, soils investigator,
Yeah.
okay.
He's-
To determine whether he can put
Yeah.
leach lines in there, okay.
Correct. So that's what we're working on. It takes time. It's just like I explained it to Philip already many a times. Every time he was there, how we're doing it. It's not that we're not going to do it right, but he's got to realize that I can't just pitch that money out and spend $20,000 tomorrow morning and put that in. We're doing it, but he doesn't have the patience or realize how us Amish work, and we don't use electric, and we won't use electric. And that appears that's the only option that we're going to have to put that system is to have electric, or unless they allow us to put a pump in and run a pump with gas and pump it up instead of doing electric, because we will not use electric. I mean, it's the bottom line, we won't. Unless I told him this morning, if we sell the property, I will make it, if an English person buys it, I will make it that the electric's in for them, that, and everything is, then they can use it. But for us, the only way out for us is either they allow us to put a gas pump in to pump it from the septic system over to the leach bed, or allow us to put half a holding tank and just get it pumped out like we're doing it right now. So some of that stuff, it's not it's not all how he was saying. And I mean, we don't get lawyers, stuff like that. I'm just here. I'm going by our work. We don't lie. So I'm just telling you the truth. So I guess whatever they want to do, if they want to lie about it, they can.
Okay. You have any questions?
No, Your Honor.
All right. Mrs. Mast, you're also a party. Do you wish to offer any testimony beside what your husband has?
I'm okay.
Okay, thank you. All right. Do you have any other witnesses you would like to question today? I mean, now?
Yeah.
Okay.
No, not that I can see
All right.
right now. No.
All
It's
right.
just.
I'll let you argue here just a moment. Now, do you have any rebuttal evidence?
No, Your Honor.
All right. Do you wish to make any argument?
Yes, Your Honor. So the bottom line here is that there's not currently an approved system on this property. That's clear from Mr. Webb's testimony. It's clear in the roundabout explanation that Mr. Mast gave also. I mean, I understand he has plans and is taking steps to try to get this resolved, but right now there's not an approved system on the property. There's been no responsive pleadings filed after the complaint was filed. The defendants have been served with a complaint. I think it's clear that they are in default here and would simply ask that the default judgment be granted and that they be ordered to abate the nuisance. That's all, Your Honor. Thank you.
All right. Mr. Mast, if you wish to make any argument at this point beyond what you've already testified to, I'll hear it. Yeah, it's up to you.
I mean, it's just like I said before.
Sure.
I'm staying by my word. I'm not gonna go over it, under it. I know that it's not an approved septic on it, but if they would realize that it's gonna be done, we're not gonna do it tomorrow morning. And it's not that we're not working on it, they don't wanna realize it, just like Philip. They don't wanna realize it that we are working on it, we are. And as far as now, like, what Philip tried to tell me that I can't pump the septic system out, have it pumped out like we're doing it right now, like a holding tank. I want to see it on paper by the law rules that that's not legal to do that, like we're doing it now, pumped out, have a holding tank pumped out, and it doesn't leak, nothing, there's nothing wrong, because I know there's many, many places that it's being done. And every time I ask him for a proof that there isn't anything that the law, I don't get it.
All right. Well, as I said, you're in default because you did not file an answer, and I understand you don't hire lawyers, and that's unfortunate, but that's the situation you find yourself in. I also will point this out, is that you indicated you moved here from New York and you didn't realize these things, and I guess that's what happens if you don't conduct an investigation. What you have to understand here, Mrs. Mast, is you've created the problem. There wasn't a problem until you started construction and then took out the system. And again, I understand that you didn't conduct an investigation, but that's your fault. There should have been inquiries about that. I don't know where you lived in New York, but most places in this country regulate sewage disposal in all areas. And so that's what's created the problem. And because you apparently built, let's say if you'd have notified them and had them come out, they could have told you where you could build your house that will allow for a replacement system. And apparently, from what I understand, he's built over part of that area. And even if you hadn't, maybe there's not enough room there. That's why they're saying you have to get an easement from your neighbor or buy that property to allow that to happen. Well, the neighbor's not under any legal obligation to sell. You can't force them to sell or give you an easement. And if you can't purchase it from him, give him enough money to agree to take it and give you an easement, which would have to be drawn up, by lawyers legally, or at least it had to be drawn up in a legal fashion that would pass muster. It doesn't look like you'll be able to fix the septic system, and that the only option is this aeration. And are there any provisions for an exception to the electrical aeration system? I mean, it can be mechanical. The rules, as I recall, the rules require electric because it has to be from an approved utility as well. It can't even be solar because and the reason for that is it has to be a stable, permanent power supply. Gas isn't permanent because it can run out and requires humans to monitor it and replenish it. Unless you had a gas line run into your property and it was always on, and that's not, that's not feasible. And so that's where you find yourself because of your actions, of your own actions. And it's not anyone else's fault. It's totally your fault that you're here. Now, I understand you say you're working on it and you can't happen just overnight, but it's been going on since March. This action was actually filed in June, but according to the attachments, actually, it was even earlier than that because it was March of 24 when there was a board meeting. So I believe that maybe the first notice was February 10th. So it's been 9-10 months. And, and the issue in terms of holding tank is that the law doesn't allow people just to have holding tanks permanently. They have to be temporary, and it has to be in a situation like they described where you're going to be able to get in an approved system. And if you know of other people that are doing it, they're doing it illegal, and if the health department finds out about it, they'll be brought in too. We do allow that sometimes when there's things being done. So the judgment of the court is, as I said, is that since you did not respond legally, you are in default. So it's the order of the court that, and the finding of the court is that you have not abated the sewage nuisance, which because of the violations of the sewage regulations and laws, that this constitutes a public nuisance, and it's therefore ordered that you abate that nuisance by installing and using an approved an operating system on the premises within 120 days from the date of this entry. So that'll give you till March. And that you must have, by that time, an approved sewage system installed, and you are ordered, well, what I'm going to do is this. I'm not going to order you to cease to generate household waste at this time, but I'm going to put in here, I'm going to add in paragraph 3 of the proposed entry, however, you can continue to use a holding tank pumped out weekly. You say it's weekly?
It's right now quite weekly, but it's like right around the month.
Every month or twice a month?
It's every month.
All right.
Sometimes a little more.
I'm going to put in here pumped regularly, and then the health department can check on that to see if it's being done as needed, at least monthly, and that's only during this 120 days. So I'm giving you a break there that the health department's not legally allowed to do, but I'm going to do it for you, give you that exception. Now, that's only for 120 days. Now, during that 120 days, you're going to need to take steps to figure out a way to fix this problem. And if you can't fix it because you won't use electric, and I understand that that's not within the beliefs of your particular group, then you mentioned the other option, sell the property to someone else that will be able to do that and put in that kind of a system. And I will allow you to reside there until, for the time being, but if you do not have an approved system, then 120 days from today, you will have to vacate the property and not live there anymore. So I'm giving you, now, if you have been able to get plans approved, and because of the weather or availability of contractors, they're not going to be able to get to it for another 30 or 60 days past the 120. The court's very lenient about that, and I would be, but again, you're going to have to work with them. It's got to be an approved system and approved plans, and they'll work with you. But again, and I understand you're in a bad situation, and I've had to have people. Well, you always want to say it. I had to kick them out of their house because they could not put in an approved system. Right. And under the law, if you can't have an approved system, then you can't live there. And so you won't be the first one that's happened to. I hope it doesn't come to that. But again, I understand that because of your particular beliefs, which I certainly respect, and understand that is the belief. Then the only option will be to vacate and sell, and unless you can come up with it. And I understand your feeling about, well, we ought to be able to have a mechanical system or something other than electric. But again, the reason for that, as I understand it from my experience on the bench and as a lawyer, is that it has to be a public utility so that it will operate without intervention from humans. Whereas, I mean, if it goes down, then obviously humans have to fix it. But it doesn't depend upon a human to check it, make sure it's operating, because when that happens, mistakes are made, people get something, so things happen. You may not, maybe get stranded in a snowstorm and the pump runs out of gas and then it fails. And so, that's why it can't be something like that. So, again, I understand your conundrum. It's unfortunate. And again, like I said, the one thing you need to understand is that, and you probably have already realized this, is that, when you went ahead and went forward without checking first, and you're not the first one that's done that by any means. It's not just because you're Amish. I mean, we have people do that all the time. And again, I'm just looking at the pleas. This system's like 32 years old, and so it's, it was probably due for a review anyway, but in any event.
Yeah, and it's like, as far as septic system, when we started there, the reason I did not go to the health department and ask, I had papers that it was approved from people that bought it from. And when we done, the contractors that I got started, I told them what I'm doing. They said that's fine. I don't have to worry about getting a permit, or not permit, which I got a permit for it. I paid for the permit.
For what?
The water and the septic. I paid that permit. So that's paid, that's.
Yeah,
not-
but you don't have a plan. I mean, you don't have
It's
an
not
approved plan, does he?
It's not, I don't have an approved.
You paid the permit fee and filed the permit
I
application.
just don't have everything that approved yet, I'm waiting on.
Right, and that's not a permit. You have a permit in progress,
Yeah, that's.
pending. You have a
that's
permit
certain.
pending. You don't have a permit. And so, I know that like I said, I understand you've been trying to do something to fix this, but unfortunately, again, where the situation is that your particular beliefs are such that it limits your options and legally. So
Right.
anyway, hopefully you'll be able to come up with an answer, and if not, if you know you're not going to be able to get it done in 120, you're not going to be able to have a plan, you refuse to put in an electric aeration system, and again, I'm not criticizing you for that. That's what your beliefs are, and that's fine. But the only other option is you'll have to vacate the property, and then it'll be up to you if you wish to sell it to someone who would come in and do it, or if you just want to hold on to it. But you won't be able to live there or let anyone else live there.
What if, it won't be able to put, if that's the only option, whatever, what if we just, I don't know if it's possible or not. If that's the case, that we just can't, like, have no plumbing.
Can't live there.
Still, even if there's no plumbing there?
Can't live there. You're generating waste. You're
Well, we
human.
have, with porta johns that we have.
That's not acceptable under the rules. Temporary it can be, but it's not acceptable. Yeah, if that were the rule, we'd have porta potties everywhere in the county. Yeah, I live in the country too. If mine went bad, I'd put a porta potty in instead of putting a new septic. But if mine goes bad, I'm going to have to put in a new one, just like you. I don't have any choice. That's only a temporary. That's not an option. Basically, they've given you your options. You may not like them, but those are the options. Yeah, they deal with this all the time.
Yeah, well, I just think it should be somewhere made that it either, it should be able to run it by like a gas motor or generator.
Well, I explained why the
know.
reasoning for that is because.
Yeah, I know, I understand.
I mean, I can't change the law, okay?
I know.
That's the law, all right? So, just keep in contact with the health department. Again, like I said, they would like to see you be able to comply. And again, that's pretty much going to be up to you. What's your options, what you wish to do with the options that are available to you. But in 120 days, if you don't comply, they could file a motion to hold you in contempt, at which time then the court, would schedule a hearing and you could end up going to jail and being fined. And nobody wants to see that happen. So, but don't expect 120 days to come back in here and say, well, we're still working on it. Because at that time, there will have to be an approved permit and an approved plan. If it's a delay for installation because of weather and scheduling, I understand that, and I'll work with you on that, because that does happen. We may have a really bad wet spring and a long winter. We haven't had one for years, but it could happen. And so, I understand that. But I can't, 120 days later, when you come in, say, well, we're still trying to figure out something. You've had since February to figure it out, and you're getting another 120 days, which I think is pretty lenient under the circumstances, because that's going to end up giving you, a year or more. And so, again, if you hadn't dug it up, and did what you did, you wouldn't be here. But, that's what happened. You can't undo the past, so we just have to live with the consequences of our mistakes. And that's what's happened. All right. Thank you. All right. Highland County General Health District versus Charles C. Cordy. Case number 24CV-199, Highland County General Health District versus Charles C. Cordy. Present on behalf of the plaintiff is Assistant Prosecutor King, and representing the Health Department's Sanitarian, Philip Webb. You're Charles C. Cordy?
Yes, sir.
All right. This is a hearing on default judgment. There was a complaint filed on July 29th against Mr. Cordy alleging that property he has located at 9083 and 9089 Water Street currently has a public health nuisance due to violation of the rules and regulations of the health department regarding disposing of solid waste by open burning or dumping. And also that's in paragraph 3, and in paragraph 4 that there's a sewage system that's not operating properly and is causing accumulation of liquid and likely sewage on the premises. So this action was filed on July 29. Mr. Cordy was served on August the 1st, and also Jennifer Cordy, I assume is your spouse.
Excuse me?
Jennifer Cordy, is that your spouse, your wife?
That's my brother. I'm Charles Cordy.
No.
Raymond Cordy is...
Jennifer. Jennifer, is that your wife?
No.
Who is Jennifer?
That's my brother's wife.
Okay, it's your sister-in-law.
Yes.
Okay, are you married?
No.
Okay, you're single. All right, thank you. All right. So, Mr. Cordy, the notice gave you 28 days to respond, and that means you have to file a written pleading, they call it, with the court and give a copy to the other side. Normally people have lawyers, but if you don't have a lawyer, you're able to do that on your own, but you did not. And so under the law, then the pleadings are assumed to be true and that you are in violation, and the question today is what the remedy would be. Now, has there been any discussions, Mr. King, with Mr. Cordy since the filing of this complaint?
Yes, I've talked to him a couple
All right, has there been any progress made
So
on the situation?
There's still solid waste on the property. About a month ago, the defendant brought a porta-john onto the property and put it next to the structure that he's living in, but that's no progress since then.
All right. So you're not denying that you don't have a functioning system, sewage system?
Yeah, no, there's not a functioning septic system.
All right, so you're admitting that, all right.
Yeah.
And there's still some solid waste, debris and so forth on the premises?
No.
All right, well then I'll need some testimony on that. So, Mr. King, if you...
I mean, there's a porta-john down there.
Yeah, okay, but let me have them testify, and then you can ask some questions, and we'll take your testimony. Would you stand and raise your right hand, Mr. Webb, be sworn? You solemnly swear the testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
Yes.
All right, thank you. Be seated. Testify from there. Mr. King, go ahead and inquire.
Could you state your name for the record?
My name is Philip Webb. I work for the Highland County Health Department. I do trash, sewage complaints. I've worked at the health department for 15 years.
And are you familiar with the properties located at 9083 and 9089 Water Street, Hillsborough, Highland County, Ohio?
Yes, this is a property right inside of New Petersburg.
And do you know who owns that property?
Yeah, it's Charles Cordy.
Okay. And let's start with the solid waste issues. Does the health department have any concerns with solid waste on the property at Water Street?
Yes, there was a large pile. So it originally started out with the house. There was a very large pile around the house that was falling down. That's how we got kind of involved with this one. And then Charles's brother, Raymond, has moved his shed home onto the property and has made new piles of solid waste on the property. But in the result of bringing the shed home onto this property, there was no functioning septic system. There was a privy, but it was a unapproved privy that's falling down. The concrete's deteriorated. It's not an approved even privy. The shed home has water run into it, and then how we got involved was there was an illegal discharge. So gray water, shower water, black water was being all discharged from this shed home.
And when were you last at this property, Mr. Webb?
I was there this morning, and I have some up-to-date pictures of the property.
Regarding the solid waste, could you kind of explain where on the property it's located and what type of waste we're dealing with here?
So there were some solid waste right beside the shed home, and then towards the back, there's also like a burn pile by the old privy, where there is solid waste and burnt material there.
Okay. I have no further questions.
Mr. Cordy, if you would like to ask Mr. Webb questions, you may do so. I'll give you a chance to testify on your own behalf here in a moment. But do you have any questions you'd like to ask him?
No, I don't.
All right. Anything further?
No, Your Honor.
All right. Now, do you wish to testify on your own behalf? Okay,
Just
raise your right
sure.
hand then.
Yeah.
Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. Now, go ahead and tell me what you'd like to say.
So my mom was on the property. She's been down there for years. She passed away a year ago. That's how the property got put in my name. This didn't start in July. This has been going on with my brother living down there for a few years. Now, there was no solid waste being dumped besides inside of the privy that was down there. There's no piles of human waste on the ground. And when my mom passed, I got a dumpster with the health department. That's what they told me to do. Set a dumpster down there, bag up all the trash that's on the ground and in the house, and so I did all that. And then I set a porta-john down there. It's been down there for a year, not just a month. It's been down there for a year and a half. Just so that they had a porta-john or a septic system to use until they figured out what was going on with the septic system. So there is a septic system on the property. We just haven't had time to go down there and deal with it, okay? My brother vacated the property last week. He hasn't been down there. This is my older brother, can testify to that. No one's living there anymore.
Okay.
I got rid of the porta-john last week. I told him to come pick it up when my brother vacated the premises. No one's going to be living there until I figure out what's going on with the septic system.
Okay. Do you have any questions you'd like to ask him?
No, Your Honor.
All right. All right. Anything else, Mr. Cordy?
No, sir.
All right. Well, as I indicated, you are in default because you didn't file an answer. It sounds like there was some progress being made on cleaning up, but then there was more happening when the shed moved on, whatever. If it is cleaned up, that's fine, but you know, the health department's got to approve that, and so it's not just you're saying it's cleaned up. They have to you have to prove to them it is. So the order is that the court finds that at the time of the filing of this complaint, you had permitted the accumulation and storage of solid waste on the premises in violation of statute and rules or regulations regarding solid waste disposal, and that there have been some other deposits since then. But so it's at word of the court that you're to remove any and all solid waste from the premises located there in a manner provided by law within 60 days of the filing of this entry. That's regarding the solid waste, the trash, etc. Now, with regard to the sewage, since you've vacated, no one's living there, that's good. But the court finds that you did violate the rules and regulations regarding the public health and created a public health nuisance by allowing generation of waste and black and gray water on the premises in violation of the rules regarding an approved sewage system. And so you're to either install an approved system within 60 days or cease allowing occupation of the premises by any person. And so you're restrained from an order not to generate any household waste on the premises. That's what that means, is no one's allowed to live there where they're doing that until that is fully abated, which means you'll have to have an approved system. And so if you're not going to allow anybody to live there, as long as they're vacated, and you say they are, then you don't have to get the permit,
Okay.
but and do the work. But if you have any plans to do that, then you have to do that within 60 days or, like I said, cease occupation. So you're actually, I believe, in compliance at this point. But at any point, you're not allowed to let anyone else move in there. or
Yeah,
occupy
no,
it.
I'm getting rid of the shed that
Don't
he was
interrupt.
living in.
All right, don't interrupt me, okay? You're not allowed to let anyone else live there or generate any waste until you have an approved system,
Okay,
all right?
yeah.
And I'm gonna add to this, and an approved septic treatment, sewage treatment system is installed. And you are required to pay the court costs of this action as well. All right, so keep in touch with them. If you want to make use of the property, they're going to tell you what you need to do in order to get a permit and then do the installation. But again, until you have a approval from them, no one can live on the property, stay at the property, or generate any waste on the property.
Yeah, right.
All right? Yeah,
Okay.
you have any questions?
No.
All right, thank you.
Please rise.
this is case number 24 CR 146, State of Ohio versus Pearly Nukem. Are you Pearly Nukem, appearing there from the jail?
Yes.
All right. This is a hearing being conducted by Zoom. It's set for pre-trial. Mr. Newcomb's appearing from the jail. His attorney is Danielle Witt, appearing from her office, appearing on behalf of the prosecutor's office, Prosecutor Collins. Defendant is charged with failure to register a change of address as a registered sex offender. I have a proposed plea of guilty form here. Ms. Witt, are you and your client both in agreement this matter can be conducted by Zoom rather than by an in-person hearing?
Yes, we are.
And you're all right with that, Mr. Newcomb?
Yes.
All right. The court has this plea agreement. It says you're going to withdraw your not guilty plea and plead guilty to the sole count of the indictment. I'm going to hold up the first page to the camera and ask if you recognize that. Has your case name and
Yes.
number? You recognize that?
Yes.
On page 3, there's a sentence that reads, I enter this plea voluntarily, and right below that is the signature, appears to be Pearly Nukem. Hold that up to the camera. Is that your signature?
Yes.
When did you sign this document, Mr. Newcomb?
Yesterday morning.
When you signed it, did you understand it was an agreement to plead guilty, which means there's not going to be a trial, and the next step in your case would be a sentencing hearing?
Yes.
And did you go over it with your attorney before you signed it to make sure you understood it and have her answer any questions?
Yes.
And do you feel you had enough time to fully consider the matter before making this decision?
Yeah.
And did you enter into this agreement to plead guilty voluntarily?
No.
You did not?
I'm pleading guilty, yes.
Okay, my question is, are you doing this voluntarily, or do you feel you've been forced to do this against your will?
Doing it voluntarily.
Okay, thank you. Now, the agreement states on page 1, you're going to plead guilty to the single count in the indictment of failure to register change of address as registered sex offender under 2950.05F1 in their Ohio Revised Code, a third-degree felony. Further states you understand that if you are convicted of that offense, you could face a penalty of between 9 and 36 months in prison and a fine of $10,000. Do you understand that?
Yes.
Are you facing any felony charges in any other jurisdiction at this time?
No.
And are you currently on probation, community control, parole, or post-release control for a felony at this time?
No.
Under the law, if you are sentenced to prison in this case, upon completion of that prison term, it is possible that you would be put under post-release control for a period of up to 2 years by the Adult Parole Authority. They don't have to, but they can. If they do, you'll be supervised on the terms they set. And if during that period of time they determine that you did not comply, then they could return you to prison to make you serve an additional period of up to 9 months for a single violation, up to a maximum of half of your prison term for all violations. However, if you're convicted of a new felony, then in addition to whatever sentence a judge in the new case can impose upon you, that judge could also sentence you for committing that offense while under post-release control in this case to an additional period of a year, whatever time is left on that period of post-release control, whichever is greater if that occurs. It has to be served consecutively to the sentence in the new case. Do you understand that?
Yes.
Now, under the law, I'm not required to sentence someone to prison for this offense. I can impose what's called community control or probation, meaning that instead of going to prison, they'd be put under the supervision of a probation officer under the term set by the court for a period of up to 5 years. And if during that period of time the court or the probation department felt that there was non-compliance, they would file a written allegation of that with the court. There would be a hearing, and if the outcome of the hearing was that they'd failed to comply, then at that time the court could revoke community control and sentence you to prison for between 9 and 36 months. And if your conviction or if your revocation was due in part or in whole to a new conviction, then in addition, whatever sentence could be, if any sentence was imposed in that new felony case, that could be served or to be served consecutive to the case in this sentence in this case. You understand that?
Yes.
All right. Now, the charge in this case alleges that on or about the period of September 11, 2024, continuing thereafter in Highland County, that being a registered sex offender convicted in Adams County Common Pleas Court case number 2010-0105, and according to the requirements of the law after 2008, that you had the duty to register and that you failed to provide notice of your change of address within 20 days by written notice and was reckless in that regard. You've previously been convicted of a offense of gross sexual imposition, felony of the 4th degree, failure to register, and being a Tier 1 registered offender, had a duty to register annually and to register notice of change of address. And it also indicates you've had a previous conviction for failure to register in this court in case number 18 CR 132 on August 24, 2018. So that is a charge in violation of section 2950.05 F1, the 3rd degree felony with the penalties I just described. Now, Mr. Nukem, do you understand the charge and what the state said you did, when, where, how they alleged you did it?
Yes.
And have you discussed the charge, the evidence in the case, the possible legal issues in the case, the possible defenses you might try to raise at trial, and the possible outcomes of a trial with your attorney?
Yeah.
Are you satisfied with her advice and competence in this matter?
Yes.
Are you under the influence of any types of drugs or alcohol at this time?
No.
Has anyone threatened you in any way to make you plead guilty here today?
No.
Now, on page 2, there are a couple of lines printed in bold and underlined that read as follows. Defendant shall enter a plea of guilty to the indictment as amended. There's no amendment here, is there?
Judge,
Yes.
the amendment would be to take out the prior conviction for failure to register, because otherwise it's mandatory time.
Otherwise, it's what?
Mandatory time
Oh, okay. So what's the amendment?
to take out the prior conviction.
All right, so it's still a 3rd degree felony, but without the prior conviction. Okay.
Correct.
So basically then what the situation is, Mr. Nukem, is by deleting the prior conviction, it's still a 3rd degree felony with a penalty, but it means it's not a mandatory prison term, meaning you couldn't be considered for judicial release or early release under a mandatory term, whereas with a non-mandatory term, you could. Doesn't mean you would get it, but you'd be eligible to apply. You understand that?
Yes.
All right, you understood that when you signed this form?
Yeah.
Okay. So, going back to quote the 2 sentences that are printed in bold and underlined, they read as follows. Defendant shall enter a plea of guilty to the amendment as indicted. State and defense jointly recommend 18 months incarceration. Now, is that your understanding of the agreement?
Yes.
And has anyone promised you anything other than that to get you to plead guilty here today?
No.
Now, under the law, the matter of sentencing is up to the judge, not the parties. And so even though there's an agreement as to what the sentence should be, the court is not required to follow that. I could impose any sentence permitted by law, which would mean between 9 and 36 months and a fine of up to $10,000. Do you understand that?
Yes.
Do you hold any license or certification from any state governmental agency that regulates any occupation or profession?
No.
You have certain constitutional rights you must understand before I can accept a plea from you. First, you have a right to have an attorney, and I appointed Ms. Witt to represent you. Her appointment wasn't simply to work the case out, but to provide any defense that might be available to you under the law that you would like her to provide. So if you decide that you do not want to do this, that you want to defend against this charge, she'll continue to represent you, including a trial, if that's what you want. Do you understand that?
Yes.
All right, now, you have a right in this case to have a trial by jury, which means that 12 people would be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After those folks are selected, the evidence would be presented. That jury then would then be instructed on the law by the judge. And that jury of 12 people would have to decide by unanimous verdict, meaning all 12 persons would have to be in agreement in order for there to be a verdict of guilty. Now, if you didn't want to have a jury trial, but you did not want to plead, well, I should say back up, with a verdict of either guilty or not guilty, whatever verdict it is would have to be unanimous. You understand that?
Yes.
Okay. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, which means you give up your right to have a jury trial. In that case, you would have what's called a quarter bench trial. That means that instead of the jury hearing the evidence, the judge hears the evidence, the judge applies the law, and the judge decides whether or not the state proves your guilt. Do you understand that?
Yes.
Under the Constitution, you have a right to cross-examine the state's witnesses in open court and to cross-examine, or you confront the witnesses in open court and cross-examine them through your attorney. What that means, a witness is against you have to come into court, testify in front of you, your attorney, and anyone else is present. After the prosecutor asks questions, you can ask questions. That's called cross-examination. The purpose of that is to try to bring out evidence that might help your side of the case. Do you understand that?
Yes.
Now, under the Constitution, you have a right to use the power of this court to compel or force witnesses to come into court to testify for you, just like the state. So if you have witnesses you're not certain are going to come in voluntarily, then the court at your request will issue a subpoena, and that's a court order, and that forces those people to come to court to be available to testify for you if you want them to, even though they don't want to be involved or be present. The same way the state's witnesses are required to come to court to testify against you. Do you understand that?
Yes.
Under the Constitution, you have a presumption of innocence, which means that the burden of proof is upon the state to prove your guilt, a proof beyond a reasonable doubt on every essential element of the offense charged. So you're not required to try to prove you're not guilty simply because you've been accused. In fact, under the law, you don't have to offer any defense at all at trial. You may, but you're not required to. But whether you do or not, the burden will remain upon the state of Ohio to prove your guilt on every essential element of the offense charged by proof beyond a reasonable doubt, which is the highest burden of proof that's known under the law. Do you understand that?
Yes.
Now, originally you entered a plea of not guilty, which denied the allegation in the indictment, denied you committed any crime. And it exercised all the rights I just described. If you change your plea today from not guilty to guilty, to the amended charge with the prior conviction deleted, that is the opposite of the not guilty plea. The guilty plea will will admit the amended indictment, admit that it's a crime, that you committed that crime. And that plea waives or gives up all of the rights that I've just described for you, except your right to have an attorney. You always have a right to have an attorney, no matter what your plea. But with that exception, your plea of guilty would waive or give up your right to a jury or court trial, would waive or give up your right to confront the witnesses against you and to cross-examine them through your attorney. It would waive or give up your right to use the power of the court to compel or force witnesses to come to court to testify for you, same as the state. It would waive or give up your privilege against self-incrimination because you're the one that's saying you're guilty, so that's what's used to find you guilty. It waives or gives up your presumption of innocence because if you say you're guilty, the state doesn't have to prove you're guilty. It also subjects you to being sentenced immediately by the court, and which is what's likely to happen here. And finally, it waives or gives up your right to file an appeal on any alleged violations of your rights you feel could have occurred up until this point. Now, if I should sentence you to the maximum sentence or under other very limited circumstances, you could file an appeal. It would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes.
And are you a U.S. citizen?
Yes.
Now, do you have any questions about the plea or, about the charge or the possible penalties?
No.
You understand them?
Yes.
Do you have any questions about the plea agreement?
No.
You understand it?
Yes.
Any questions about the constitutional rights I've explained?
No.
You understand those?
Yes.
And do you understand what the consequences of a guilty plea are if you enter that here today?
Yes.
Now, I didn't tell you this earlier, I forgot, but if you need to talk to Ms. Witt about anything before we go any further, I can put you and her into a breakout room. We'll be just the two of you on the screen talking. No one else will be able to see you or hear you. And while you're talking with your attorney, the deputy would step out of the room so you would have a private conversation. Do you need to do that for any purpose at this point?
No.
Okay, do you have any questions at all?
No, sir.
Then is it your decision to withdraw your not guilty plea, plead guilty to the amended charge in the indictment, meaning the prior conviction is deleted, pursuant to the terms of this plea agreement that we've gone over here this afternoon?
Yes.
Right, then as to the charge, which reads as amended, that beginning on or about September 11, 2024, continuing thereafter in Huntington County, Ohio, you did being a registered sex offender convicted out of the Adams County Common Pleas Court, case number 2010-0105. According to his requirements of the law, after 2008, having a duty to register address, failed to provide notice of his address within 20 days by written notice and was reckless in that regard. Having previously been previously convicted of gross sexual imposition, a felony of the 4th degree on October 27, 2011, defendant being a registered Tier 1 registered sex offender having a duty to register annually and having a duty to register a notice of residence, and that you have, okay, in violation of section 2950.05 F1. And so I didn't read the last part because that had been deleted. So, by the amendment. So, how do you plead to that charge, the third-degree felony with the penalties I've previously explained?
Guilty.
All right, thank you. All right, the court finds that on this date in open court, the defendant was advised of all his constitutional rights, made a no intelligent voluntary waiver of the same pursuant to criminal rule 11. The plea is accepted and ordered filed. The defendant is found guilty of the amended charge of the indictment as described in the plea agreement, and the court is on the original indictment striking out the allegations of the prior conviction, deleted by amendment, so that when this goes to the prison, they won't be sending me a notice saying it should be a mandatory offense. The defendant is found guilty of the offense, and the court finds that that the defendant's plea was made knowingly and voluntarily pursuant to criminal rule 11. And I'll put in my initials and the date next to that language of deleting the amendment, or deleting the prior allegation of, or the allegation of prior conviction. All right, now the court's going to go ahead and proceed with sentencing, given the nature of the offense and the fact that there's a stipulated joint recommendation. And so, anything from the state regarding sentencing?
Only what's contained in the plea agreement, Your Honor.
Okay. All right. Ms. Witt?
Yes, Your Honor. We also ask the court to follow the joint recommendation that's contained in the plea agreement. We feel that that is ample time for Mr. Nukem to serve, and that he is remorseful as well. And he's been extremely cooperative as he is pleading today, and it's just his first pretrial.
All right. Mr. Nukem, you have anything that you would like to say?
No.
All right. I'm looking here. When you were arrested, we don't have a jail time credit, but the charge was filed on October the 8th. Do you recall the date you were arrested?
October 8th, I think.
Same date?
Yes, sir.
I'll look here. Do you see anything in your file there, Ms. Collins?
I'm looking right now.
Yeah, I'm looking for the return in the municipal court case, and says he was in court on 10. No, that was 10/8. It was an appearance, so it would be 10/8. All right. All right. Is the order of the court that the defendant be and is hereby sentenced to the Correction Reception Center at Orient, Ohio, for a period of 18 months. The defendant will be given credit for jail time since his arrest on October 8th. So,
Your Honor.
I'm sorry?
He was actually arrested on the 7th.
7th? Okay. All right. So the court then will give you 24 days of jail time credit from the 7th, and 20 days as of today. So that will be 44 days of credit toward that sentence. Now, upon completion of this sentence, Mr. Nukem, the Adult Parole Authority may put you under post-release control for a period of up to 2 years. If they do, you'll be supervised on the terms they set, and if you don't comply, they could return you to prison and make you serve an additional period of up to 9 months for one or more violations. But if you commit a new felony, then in addition, whatever sentence a judge in a new case can impose upon you, that judge is also authorized to sentence you for committing that offense while under post-release control, in this case, to an additional period of 1 year, whatever time's left on that period of post-release control, whichever is greater. If that occurs, that has to be served consecutively to the sentence in the new case. You're also ordered to pay the court costs, which judgment, grant, and execution is ordered. If you fail to do that, then the clerk can collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then upon completion of your sentence, not while you're in prison, but once you get out, the court could order you to do community service in this county and give you credit for each hour you work in an hourly rate set by the court. Each hour you work will reduce your judgment by that amount until paid in full. All right, is there anything further from counsel?
Your Honor.
All right,
No,
thank
Your
you.
Honor.
All right, Deputy, I need Randy Alexander next, and after that, Brian Duncan.
Yes, sir.
All right, this is case number 24 CR 150, State of Ohio versus Randy Alexander Jr. And are you Randy Alexander Jr. appearing there from the jail?
Yes, Your Honor.
All right, this is case is being pretrial being conducted by Zoom. Mr. Alexander is noted previously is appearing from the jail. Attorney Sarah Barger appearing from her office by Zoom, appearing from the prosecutor's office. Also by Zoom is Prosecutor Attorney Collins. Defendant is charged with aggravated possession of methamphetamine, a fifth-degree felony. It's the first pretrial. Final pretrial set for the 11th of December. Trial date is set for January 13th. Excuse me. I note that the state's provided filed the bill of particulars and a discovery. It looks like Ms. Barger filed her reciprocal discovery also on the 20th. Okay. I see that the bill of particulars looks like was filed before the request for discovery, but you do have your discovery?
Yes, Your Honor, I have everything.
All right, yeah, it looks like you just filed a demand today, but anyway. Do you, if there's any further discovery, it'll be due by the final pretrial if either party has any further discovery to provide to the other. Do you anticipate any pretrial motions, Ms. Barger?
I filed a motion for intervention in lieu of conviction today.
Oh, okay. All right, have you filed the stipulated questions with that?
I went out and saw my client. I have them in my possession. I'm going to bring them up. They'll be filed this afternoon.
All right, well, upon receipt of that, then the court will order an evaluation and a pre-hearing report from the probation department. All right. Anything further from counsel?
No, Your Honor.
All right.
No, Your Honor.
We'll, as soon as we get that motion from the clerk's office, I'll order that to be done. Mr. Alexander, the probation department will be out to see you and to discuss the matter with you, and then we'll set a hearing in about 3 to 4 weeks after today, probably about 4 weeks from today. All right, thank you. All right, Brian Lee. All right, are you Brian Lee Duncan appearing there from the jail?
Yes.
Okay, this is case number 24 CR 151, State of Ohio versus Brian Lee Duncan. This is a pretrial being conducted by Zoom. Mr. Duncan's attorney is Dennis Kirk, appearing from his office, appearing from the prosecutor's office, Prosecutor Collins. The defendant is charged in one count indictment of aggravated possession of methamphetamine, a third-degree felony. This is a first pretrial, final pretrial set for December 18, trial set for January 13. I see there was a request for bill of particulars filed, and I see a request for discovery by the state and the state's compliance. Did you get the bill of particulars filed yet, Ms. Collins? Has not made it up here if it have.
We filed on the 15th.
All right, we'll look for it. All right, Mr. Kirk, you did get your discovery?
I did, Your Honor, yes.
All right, your discovery is due by the final pretrial then. And do you anticipate any pretrial motions?
Not at this time.
All right, well, if you do determine any are appropriate, you'll need to file those by the final pretrial. Have you received a written plea offer yet from the state?
I have, and I have relayed that to my client.
All right. All right, are there any other matters to discuss then at this time in this case?
No, Your Honor.
All right, your next pretrial will be the 18th then, Mr. Williamson. All right, thank you, Mr. Duncan. Ms. Hapner is in juvenile court, so I think I need the calendar. And do you get it? Hold on.
I got it on the line right now.
What's going on?
Right now, there's a violent windstorm, and he's on top of the roof.
Case number 24 CR 116, State of Ohio versus Justin Alexander Brooks. You're Justin Allen Brooks.
Yes, sir.
All right, this is a pretrial being conducted pursuant to the assignment notice report setting the matter, which was, I believe, issued on October the 31st. Defendant is present. Representing the state is Assistant Prosecutor King. Attorney James Chandler did not appear. Mr. Chandler entered an appearance in this case on October 24th. We had a status conference set for the 31st of October. He did not appear for that. We had no, well, it was noticed, it was a Zoom hearing, and as I recall, he was notified to not log in. Is that correct, Ms. Zoyer? Right. So the court then set the matter for a hearing today. Mr. Chandler has not appeared. My understanding from Ms. Zoyer is that she finally reached him and he claims he's on the roof because he's had a bad storm in his residence. Okay, and when did that supposedly happen?
Just now.
Well, okay. Well, he lives in Beaver, Ohio, so I have the weather here on the Weather Channel in Beaver, Ohio, 125. It shows showers with a wind 7 miles per hour. I have some doubts as to that veracity of that story. So it is the order of the court, this matter be continued until Monday, November, what is that, the 22nd?
25th.
25th? Yes, 25th at 2 o'clock. And it is ordered that Mr. Chandler be present in person at the appointed time or be subject to contempt. And the court will also reserve ruling on whether he's in contempt for failure to appear today. Is my understanding he's told Ms. Foyer, the assignment commissioner, he didn't have on his calendar, but he would have been notified of the hearing and received a copy of the entry that the court put on the 31st from the clerk. So there's really no reason for him not to be here in the court's view. And we'll wait and see. All right. So you get your assignment notice from the, just step around there, get your assignment notice, and be here next Monday.
Do you want to see these?
No, you'll need to have that presented through your attorney. Okay. All right. All right, this case number 24 CR 125, State of Ohio versus Village of Stowe. Appearing on behalf of the state is Assistant Prosecutor King. Appearing on behalf of the defendant is Dennis Kirk, and you are Village of Stowe.
Yeah.
All right, there we go. All right, the defendant is charged with 1 count of aggravated possession of methamphetamine, a third-degree felony. This is the first pretrial. Final pretrial set for December 11th. Trial date is January 13th. All right. See that the state has provided discovery, and you received that, Mr. Kirk?
I have, Your Honor.
All right. Your discovery will be due by the final pretrial. You anticipate any pretrial motions?
Not at this time.
And has there been a written plea offer provided?
There has, and I have made him aware of it here today.
All right. Does counsel have anything else?
Nothing from the state, Your Honor.
All right. Mr. Stone, why aren't you in jail?
What's that?
Why aren't you in jail?
Furloughed.
Yeah. Furlough said that upon discharge from the hospital, you report immediately back to jail.
I was at Cincinnati. I was at Cincinnati Hospital 3 days ago.
Uh-huh. Well, okay, why didn't you go back to jail then 3 days ago? Take him into custody. You were supposed to report back to jail. Your furlough was temporary. You're going back to jail.
We just note for the record, Your Honor, he does have a pacemaker that they just installed, and he has some upcoming follow-up appointments. I don't know what those entail or how, if that will create any issue, but I just want the court to be aware.
Okay, well, if he wants to provide proof of all that from his doctors, well, we got to look at it. But he was ordered to report back to jail. He didn't report to anybody. So, you know, if he has a medical condition, he has an obligation to be in contact with you. Have you talked with him before today?
No, not until
Okay, see, that's your problem, Mr. Stone. You're not communicating with anybody. You're just doing what you want. Okay? You need to keep get your medical records, get your attorney informed, and then we'll discuss your what your bond situation is. But when I issue an order and I tell you, when you get out of the hospital, you report back to the jail, I mean what I say. And when you don't do it, this is what happens. Okay? You should already been there. Now, if you need to have further furlough for treatment, I'll consider that. but you just don't not show up back when I ordered you to do something. Now, I'll give you credit for showing up here today, but you get your proof to your attorney, and he can file a motion, and we'll look at it. But the next time I tell, and if you do get out of jail, if I do release you further, you're to report to the probation department. Because the order originally said, if you get released, you report immediately to the probation department. So you need to understand is you're not in charge. You know, your life is controlled by your bond conditions, including house arrest. Now, you can go to medical appointments if you're out on bond, and the other things that I told you about, and probation will explain that to you. But, you know, you need to comply with the court's order. All right? So, Mr. Kirk, if you can get that information, I'll look at it, and get a decision that'll, take that all into consideration. All right?
Thank you, Your Honor.
Thank you. All right, Ms. Hapner's logging in, so could we get Mr. Williamson there at the probation department on?
I'll get him, Your Honor.
All right, thank you. All right, this is case number 24 CR 148, State of Ohio versus Timothy J. Williamson. Are you Timothy J. Williamson appearing there from the probation department?
Yes, sir.
Get a little feedback there. All right, this is a pretrial being conducted by Zoom. Mr. Williamson is represented by Attorney Catherine Hapner, appearing from her office. Appearing from the prosecutor's office is Prosecutor Collins. Defendant is charged with 1 count of aggravated possession of methamphetamine, a third-degree felony. This is a first pretrial, final pretrial set for the 18th of December, and the trial date is set for January the 27th. The court notes that the state has provided discovery and a bill of particulars, and you received those, Ms. Hapner?
I have, yes.
All right. And I can't, did you file your discovery yet? I don't think you did you?
I've not filed mine yet.
All right, well, you have until final pretrial, of course. And do you anticipate any pretrial motions?
Not at this time.
Okay. If you do determine there are any that need to be filed, they'll be due by the final pretrial as well. Have you received a written plea offer?
I have received that. I've not met with my client yet to, go over it with him.
All right. All right. Are there any other matters that need to be discussed then?
No, Your Honor.
Okay. Stay in touch with your attorney, Mr. Williamson, and so that she can discuss matters with you before your final pretrial next month. So.
All right, thank you, sir.
All right, thank you. All right, the next case is State versus Nikki.
Your Honor, she is still not here.
Okay, good. Wait, well, I'm on record, but let me get everything identified. Case number 24 CR 101, State of Ohio versus Nikki Nicole Brandt. This is a pretrial scheduled by Zoom. Was set for 2 o'clock. Ms. Hapner, Catherine Hapner of Hillsborough, is appearing by Zoom from her office on behalf of the defendant. Appearing on behalf of the state is Prosecuting Attorney Collins. The court was, though the matter was set for a hearing at 2 o'clock, it's now 2:08 by the court's watch. I also have and she is not present according to Officer Benson at the probation department. She is not present in the courtroom. And I have a notice here from the probation department that she's failed to report since October 29th, which probably was the day she was released on bond. Yes. I assume you haven't had any contact with her, Ms. Hapner?
The only contact I've had was this morning when she called about the pretrial this afternoon, and I'm not sure whose number, and I did not speak with her directly because I was in juvenile court this morning, but my assistant spoke with her, and she said she did not have a phone, so I don't know whose phone she was using, and that she did not have a ride. And my message back to her was, you need to get to the probation department today. You can do the Zoom pretrial from there. So that's the only contact I've had.
Okay. Well, it appears that she's not reported. Did she report on the 29th, Officer Benson?
Yes, sir.
Okay.
But she
All
bought
right.
that.
Well, the court will, due to the fact that she's not been complying with the order of the court to report weekly since her arrest on October 29th, today would be the 20th, so that's a period of a little over 3 weeks. So she would have missed at least 2 reports. And the fact that she's failed to appear here today. The court's going to order a CAPUS issue for her arrest, and we'll put the matter on the inactive docket until such time as she is taken into custody and brought back before the court. All right, anything further, counsel?
No, Your Honor.
All right, thank you.